Hey guys, welcome to IP series COVID-19 edition, where we talk on recent IP cases and development globally. IP, like I've always stated, is basically everywhere, and we know IP protects creative and innovative work, which could be in form of a copyright, a trademark, a patent, industrial design, trade secret, geographical indication, etc. Now, it is also advisable to register your work so you can enjoy legal backing and protection. With this, I welcome you to today's episode and topic, which is titled Reasons Why Your Trademark Application May Be Rejected. My name is Rita Amwiri-Chinda, and this podcast was edited and recorded by me. Now let's get right into it. So, in the last 2-3 seasons, I think I started introducing news flash or hot topic. So today's news flash / hot topic is that on the 30th of June, 2020, the Nigerian Trademark Registry published its trademark journal for opposition of marks, which will run for the next 2 months. Now, this is done according to Section 13 and 63 of the Nigerian Trademark Act for publication of notice of application. So if you've recently made a trademark application, take note that your opposition started counting from the 30th of June, and this will run till the 30th of August. Now, Section 20 of the Trademark Act also talks on opposition to registration, which may be done within 2 months from the date of the publication as stated initially. So I already explained that the Trademark Registry published its journal on the 30th of June. So agents take note, IP lawyers, firms take note. So let's get right into our case study. So our case study for today is the Valentino against the Trademark Trial Appeal Body, which is also known as the TTAP. So if you want to read more or look at the decision of the appeal board, it's that is RE Valentino SPA. So S.P.A. Serial number 79228160. So if you've heard of Valentino, if you bought a Valentino brand, the original or not the pirated one anyways, but yeah, so Valentino is a luxury brand and an Italian fashion house which was created in 1960. In 2010, they started accessorizing their bags and shoes and clothes with rock studs, thereby creating a rock stud range, which also increased their sales and revenue between 2013 and the end of 2018. So in 2013, they made $590 million. I mean, that's a lot. But just check out the progression, how much it grew. So at the end of 2018, Valentino sales was $1 billion, $1 billion, and that was the same year that Apple became the first $1 trillion company. But that's another story for another day. So, why this case? Why is it really interesting? So, from December 2010 to October 2019, the legal team, of Valentino tried registering rock stud. Like I said initially, they started using rock stud in all their shoes and clothes and bags in 2010. Since 2010, and decided to trademark the name rock stud and rock stud spike for its appearance on the shoes, the bags, and the clothes in international class 18, 25, and also as a standard trademark, as a standard character. This later evolved into a multi-year fight between the legal teams of Valentino and the various arms of the USPTO, because when they initially made the application to register, it was rejected. The the body rejected it, stating that the three-judge panel upheld the decisions of the USPTO to refuse to register the word spike because it was considered to be descriptive. So, in 2018, the National Trademark Body also issued an official refusal to register the mark because it was descriptive in nature instead of, being a source identificator of the goods. So when they say your mark is descriptive, that means if I hear the word iron, like I want to name my brand Iron, my range of irons, Iron, it already describes what my product is, and that's not what a mark should do. It should, be distinctive or fanciful or original or something. So trademark, as we know, is a source identifier. It's used to identify goods or services that the mark is being registered in, which could be the name or the logo or the sign or the symbols or phrase, just like Nike Just Do It, or numbers, or a non-traditional trademark could be in form of the three-dimensional shape, its smell, hologram, etc. Instead of now, the panel, the appeal board asked Valentino to amend its application. Just remove the spike from your rock stud is not, doesn't qualify as a trademark. But instead of amending the application, they requested that the registration be reconsidered and further appealed the decision of the USPTO to the TTAB, that is the Trademark Trial Appeal Body. Now, in Nigeria, according to Section 21 of our Trademark Act, the decision of the registrar shall be subject to appeal to the court. So, if, as it is in the Valentino case, that the Trademark Office refused to, register the word, you can make an appeal at the Federal High Court, so the judge can listen to your case. However, this appeal must emanate from the opposition stage, which is not the case here. The rock stud application or rock stud spike was not opposed, rather it was refused to be registered. In Rule 34 of our trademark regulation, it provides that after search and consideration of an application and any evidence of use or distinctiveness supplied by the applicant, the registrar may accept the application absolutely, or he may object to it or express his willingness to accept it. And this is subject to conditions, amendments, disclaimers, modifications, or limitations as the registrar may deem fit to impose. There was also this was the issue in this Valentino's case. The legal team and counsel were given the option to amend the application, but they refused to amend the application, and rather chose to appeal the USPTO decision to the TTAB, that's the Trademark Trial Appeal Body. Now, Rule 35 of our Trademark Act also provides that if the registrar objects to an application, he shall inform the applicant in writing, and this must be done within 2 months by the applicant applying for a hearing. The applicant must apply for a hearing or make in writing to the objection of the registrar, else it will be considered that the application has been withdrawn. The time limit for this is for the registrar's condition and hearing shall be within 1 month from the date of communication applying for a hearing, else it will also be considered that your application has been withdrawn. So what are the reasons why your trademark application may be rejected? So if the mark is not distinctive enough, I know I stated it earlier, this means that if I see brand A, B goods or services or product, I should be able to differentiate them. If I can't differentiate them, that means it's causing confusion. So that's another reason why your trademark may not be, your application may not be may be accepted and it will be likely to be rejected. If it causes confusion amongst the consumers in relation to the extent of the registrations, this is in line with Section 9 of the Trademark Act, especially subsection 3 of the Trademark Act. Example would be cold and creamy. So if you call your ice cream cold and creamy ice cream, we already know that ice cream is cold and it's creamy. So why do you need to call your ice cream cold and creamy? So examples of ice creams would be Ben & Jerry, Haagen-Dazs, Supreme ice cream, the Fan brands. Then it also makes the attribute or ingredient of the mark to be very weak. So if I hear cold and creamy, it doesn't really hold water. So when choosing a mark, make sure that it's good enough and strong enough. Another reason why your trademark application may be rejected is if there's a similar mark out there. So if there's a Ben & Jerry mark out there in the same class, and it's going to cause confusion, then your mark may not be registered. If there's a so now the question will now be, can two brands bear the same name? Yes. So yes. However, it has to be in a different class. So the case of Steve Jobs against Steve Jobs, where and two brothers named their clothing line Steve Jobs, and the Apple company or the heads of Steve Jobs sued them, saying they can't use Steve Jobs as a trademark, and the court said it's not possible because Steve Jobs did not register the word or name Steve Jobs for fashion line, so they lost that right to restrain anybody from using that mark. Another reason could be if the mark you seek to register is generic in nature. For example, if you're Nigerian, people want to buy pens, instead of saying I need to buy a pen, they say give me Biro or give me Bic. Bic is a brand name. You want to buy detergent and you're saying give me Omo. There are different brand names. You have Sunlight, Omo, Ariel, you want to buy seasoning cube, you say give me Maggi. Meanwhile, what you want is Knorr Cube or Royco. You want Indomie noodles, in particular brand noodles, and like give me Indomie. Indomie is the brand name. Why? I don't know if you guys get my point. So sometimes when this was become too common, it starts to lose its distinctiveness. For instance, Google is a brand name, but it became too generic because it was referred to as internet search engine. Ping pong, table tennis became too generic. Post-it, sticky notes, it became the generic term. Vaseline, petroleum jelly became the generic term. Another reason why your mark may be rejected is if it is deceptive or scandalous, it cannot be registered. According to Section 11 of the Nigerian Trademark Act, if you try to register the names of chemical substance, it will not be accepted as well. So what then qualifies as a strong mark or distinctive mark? So any mark that is arbitrary in nature or is fanciful or coined is considered to be positively strong. So brand names like Samsung, Thermocool, that's a brand name. Ford, BMW, those are arbitrary and coined words that were registered as trademark. So how do you select a strong trademark for your as a business person or as an entrepreneur? So the primary goal, first of all, should be wanting to establish your brand presence in the market. So when people hear about your brand, what's the first thing you want people to think about when they hear your brand? You also want to be able to prevent other people from registering a similar mark. You also get to enjoy legal backing, especially when the mark is registered. It must meet the requirements of being distinctive in nature, as stated in Section 9 of the Nigerian Trademark Act. Now, when the TTAP, that's the Trademark Trial Appeal Body, was coming up with their decision, they stated that the word spike is used to describe a feature of a dog collar. Apologies. Yeah, so you can imagine So if you were to Google Spike now, you will see different brands or products that have used spikes in their products. For instance, Gucci has a shoe line that has a spike. Farfetch also has, all those, any product you see with the spiky or studs on it. That's it. So you also need to remember that trademark is a valuable intangible asset that can be exploited or commercialized. Also know that trademark is territorial in nature, so registration is very important. The term of duration for a trademark is 7 years, and it is subject to renewal for 2 consecutive 7 years, which is equal to 21 years. However, you can extend this by creating an IP portfolio, an IP strategy, and also having a brand strategy and expansion. For instance, Amazon has about 1,500 trademark registered. I mean, that's a lot, and you must know how much it took them to invest, and build this many trademarks. So I think it was in the last or two sessions where I talked about Kanye making the registration for Yeezy to be used on various products. So that's one of the things you can do. Think of brand expansion and what you can do with your trademark. On the 15th of April, the TTAB, that's the Trademark Trial Appeal Board, said that the word spike in the proposed mark, rock stud spike, is merely descriptive of the goods and must be disclaimed, and affirm the refusal of the USPTO to register the word spike or rock stud itself. But however, he allowed the applicants 30 days to submit a disclaimer of spike as provided in in Section 6A of the U.S. Trademark Act, and also Section 15 of our Nigerian Trademark Act provides that a disclaimer for registration purpose can happen if a trademark contains matter common to the trade or otherwise of a non-distinctive character. The registrar or the court in this case will be the Federal High Court, in deciding whether the trademark shall be entered or shall remain on the registrar. They may require as a condition that it be on the registrar. So the applicant shall disclaim any right to the exclusive use. So when you have an IP, you have exclusive right to use the mark alone. But in this case now, you will disclaim any rights to the exclusive use of that particular mark, which is really sad, but yeah, it is what it is. So in conclusion, we're wrapping up now. You need to consult an IP lawyer, have 1 year retainer, so you can be properly guided when it comes to your IP registration and protection. Don't just have one lawyer for everything. They have lawyers who are specialized in all of these things: tax law, immigration law, company law, IP law. You get my point. So always do a search of the IP before proceeding to register it, so that you don't have to cancel your registration at some point. That will be another topic for another day, but not today. Also, after registering it, you need to consistently use the mark after it's been registered. So with that, we ended today's IP series. I want to say a huge thank you to everyone who has, always tuned in or listened to my podcast when I share them. So you can listen to my podcast on Anchor, Spotify, Apple Podcast, Breaker, Radio Plus. So if you have questions, you can send us to us an email, ipseriesinfo@gmail.com, or PARDO, PARDO, primelegal@gmail.com. You can also send me a DM on my Twitter, Esmeraldo99. You can also send me a message if you have my number. But thank you guys. Thank you for listening. If you learned something from this particular session, do let me know. Until the next IP series, stay safe, observe the healthy measures, set out by the health body. And yeah, have a good day, guys. Thank you once again, and bye.